This is a CBS News special report. I'm Norah O'Donnell here in Washington, and we are coming on the air as Special Counsel Jack Smith is delivering remarks on the indictment of former President Donald Trump any moment from now. Just over an hour and a half ago, the 38-count indictment was unsealed, 37 of them specifically targeting Mr. Trump. And the accusations made in this indictment are stunning. They allege that the National Archives repeatedly demanded that the former president turn over classified documents beginning in May of 2021.
Okay, so let me just say this right up front. What I'm about to tell you is one of the wildest things I've ever covered on this channel. And I know I say that a lot, but this time I genuinely mean it. Because what just happened, what we just watched unfold over the past few months, is something that legal scholars, historians, and everyday Americans are going to be debating for decades. This is not some small legal technicality. This is not some procedural footnote. This is the kind of story that changes how we think about power, accountability, and whether anyone, and I mean anyone, is truly above the law in this country. So buckle up, because we have a lot to get through today. But before we go any further, real quick, let's be honest, you can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
Are related to Trump's mishandling of documents. You see now Jack Smith, and we will hear his first remarks on what has been a 14-month-long investigation.
Good afternoon. Today, an indictment was unsealed, charging Donald J. Trump with felony violations of our national security laws, as well as participating in a conspiracy to obstruct justice. This indictment was voted by a grand jury of citizens in the Southern District of Florida, and I invite everyone to read it in full to understand the scope and the gravity of the crimes charged. The men and women of the United States intelligence community and our armed forces dedicate their lives to protecting our nation and its people.
Here's the short version. Every single criminal case against President Trump, every single one is now gone. Poof, vanished, done. The Georgia election case, dismissed. The federal election interference case, dropped. The classified documents case, gone. Come on, are you kidding me? And here's the part that's going to make your head spin. The prosecutors themselves, the people who built these cases, they're on record saying they believe they had enough evidence to convict him. Let that sink in for a second. Jack Smith, the special counsel who spent 2 years investigating Trump, wrote in his final report that the evidence was sufficient to obtain and sustain a conviction at trial. He believed he could have won. He believed the jury would have found Trump guilty, but he never got the chance to prove it. This is wild. Now look, I know what some of you are thinking. You're thinking, well, Trump won the election, so of course the cases got dropped. And yeah, okay, that's technically true, but it's way more complicated than that. Because what we're really talking about here is something much bigger. We're talking about whether the most powerful person in America can ever truly be held accountable for anything. We're talking about a system that basically said, yeah, the evidence is there, but timing. We're talking about prosecutors who quietly admitted we could have convicted him, but politics and rules got in the way. And I gotta be honest with you, this story matters. It matters whether you love Trump or hate him. It matters whether you voted for him or against him. Because what happened here sets a precedent. And precedents, they don't just affect one person, they affect everyone who comes after. Think about it this way. If you're a future president and you're thinking about bending the rules, maybe breaking a few laws, what lesson do you take from this? The lesson is simple. Win the election and you're untouchable. That's not me saying that. That's just what happened. Those are the facts. So today, we're going to break this whole thing down. All of it. We're going to look at what Jack Smith's final report actually says. And trust me, there's stuff in there that will blow your mind. We're going to examine why the Georgia case just got thrown out last week. The timing is insane. We're going to talk about the Supreme Court's immunity ruling and how it changed everything. Because that decision, that's the one nobody's talking about enough. And most importantly, we're going to answer the question everyone's been asking. Did Trump beat the system? Or did the system decide it just couldn't handle prosecuting a sitting president? Because the answer is actually both. And neither. It's complicated. Stay with me here, because this is going to be a long one. But I promise you, by the end of this video, you're going to understand exactly how a man facing 4 criminal indictments managed to walk away from all of them without ever going to trial. And you might not like what you hear, Now, before we dive in, I want you to really think about what I'm about to say. Imagine you're charged with a crime. 4 separate indictments, actually. Grand juries in multiple jurisdictions looked at evidence and said, yeah, there's enough here to bring charges. You hire lawyers, you fight the cases, you file motions, you appeal, and then somehow all those cases just disappear. Not because you proved your innocence, not because a jury said not guilty, but because of timing and legal technicalities. Most Americans would never get that outcome. If you or I were facing federal charges, we'd be sitting in that courtroom. We'd be facing a jury. We'd get a verdict. But when you're the president of the United States, different rules apply. And I'm not saying that's wrong or right. I'm saying that's what happened. Those are the facts. So let's get into it. All right. So to understand how we got here, we need to go back a bit because this story didn't start last week. It started years ago. Let's start with the federal cases. In November 2022, Attorney General Merrick Garland appointed Jack Smith as special counsel. His job? To investigate 2 things. First, Trump's role in the January 6th attack on the Capitol and his efforts to overturn the 2020 election. Second, the classified documents Trump allegedly kept at Mar-a-Lago after leaving office. Now, Smith didn't mess around. This guy is a career prosecutor with nearly 30 years of experience. He brought in some of the most experienced prosecutors in the Department of Justice. He interviewed over 250 witnesses voluntarily. He called 55 people before a grand jury. He executed dozens of search warrants and subpoenas. He sifted through literally a terabyte of publicly accessible data. This was not some half-baked investigation. This was the real deal. And in August 2023, a federal grand jury indicted Trump on 4 felony charges related to election interference. This was unprecedented. No former president had ever been charged with crimes related to actions taken while in office. We were in uncharted territory. The charges included conspiracy to defraud the United States, obstruction of an official proceeding, and conspiracy against citizens' rights to vote. Heavy stuff. Really heavy stuff. Smith's investigation found that Trump spread election fraud claims he knew were false. His own advisors, including the vice president, had told him there was no evidence of widespread fraud. Attorney General Bill Barr told him publicly that the Justice Department hadn't found outcome-changing fraud. State officials in Arizona, Georgia, Michigan, Pennsylvania, they all told him his fraud claims were wrong. His own campaign conceded litigation in Arizona. Courts rejected every single lawsuit claiming election fraud. Trump knew. According to Smith's investigation, Trump knew. But here's where it gets really interesting. The report details how Trump allegedly pressured state officials to ignore vote counts. Remember that phone call to Georgia? The one where he asked Secretary of State Brad Raffensperger to find 11,780 votes? That's exactly the margin he lost by. That's not a coincidence. The report shows how Trump and his allies organized fake electors in 7 states he lost: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin. They had people sign certificates claiming to be legitimate electors when they weren't. Can you believe this? And the evidence shows these weren't just confused supporters. Internal emails from Trump's campaign called the plan kind of wild and creative and suggested using the term alternative votes instead of fake votes and keeping it under wraps until Congress counts the vote on January 6th. They knew what they were doing. Then there was the pressure on Mike Pence. Day after day, Trump allegedly pressured his vice president to refuse to certify the election when Pence said he didn't have the authority to do that. Trump reportedly told him that hundreds of thousands of people would hate his guts and that Pence was too honest. As if honesty is a bad thing when you're trying to overturn an election. And then January 6th happened. Smith's report says Trump told his supporters the election was stolen, called them to Washington, told them it would be wild, and directed them to march to the Capitol. During his speech at the Ellipse, he used the word fight more than 10 times. When the violence broke out, multiple advisors rushed to tell him about the riot. They begged him to issue calming messages. They told him people were breaking into the Capitol. But according to the report, Trump resisted. He kept saying the people were angry because the election had been stolen. Then at 2:24 p.m., while alone in the White House dining room watching Fox News on TV, Trump tweeted an attack on Mike Pence. He said Pence didn't have the courage to do what needed to be done. 1 minute later, the Secret Service had to evacuate Pence to a secure location because the mob was getting too close. When an advisor told Trump that Pence had been evacuated, you know what Trump reportedly said? So what? Meanwhile, rioters were chanting, "Hang Mike Pence," inside the Capitol. 140 law enforcement officers were assaulted that day. People died. This is all in the official report. This isn't some blogger's opinion. This isn't cable news speculation. This is what federal prosecutors documented after 2 years of investigation. But here's the thing most people get wrong about these cases. Trump didn't beat the charges on the merits. He didn't prove his innocence in court. He didn't have a jury find him not guilty. He didn't win on appeal. What happened was the Supreme Court changed the rules. In July 2024, the Supreme Court ruled that presidents have absolute immunity from prosecution for official acts within their core constitutional authority. For other official conduct, they get presumptive immunity. Only unofficial acts can be prosecuted. This was huge. This was a game changer. It meant prosecutors had to go back and figure out what was official and what wasn't. It created delays, appeals, motions, more delays, and then Trump won the 2024 election. Once that happened, it was game over for the federal cases. The Justice Department has a long-standing policy that sitting presidents cannot be prosecuted. That policy dates back to the Watergate era, so Smith had to drop the charges. But, and this is crucial, Smith didn't just walk away quietly. He wrote a 137-page report laying out all the evidence. He wanted the public to know what he found. He wanted the historical record to show what happened, and what he found was damning. Smith wrote that, but for Trump's election and imminent return to the presidency, the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. Read that again, slowly. The prosecutors believed they would have won. They believed the jury would have convicted Trump on at least some of the charges, but the election and that DOJ policy took that option off the table. Smith also defended his investigation against Trump's claims of bias. He wrote that to all who know me well, the claim from Trump that my decisions as a prosecutor were influenced or directed by the Biden administration or other political actors is, in a word, laughable. Now let's talk about Georgia, because that case was supposed to be different. That case was supposed to be the one that couldn't be stopped. This was a state case, not federal, which meant Trump couldn't pardon himself. He couldn't fire the prosecutor. He couldn't order the attorney general to drop it. In theory, this case could have survived his return to the presidency. That's why so many people thought Georgia was the real threat to Trump. It was outside the federal system. It operated under different rules. Fulton County District Attorney Fani Willis charged Trump and 18 co-defendants with racketeering in August 2023. This was the famous case where Trump got his mugshot taken. That image became iconic. It was everywhere. On t-shirts, on posters, on merchandise, Trump himself sold. The charges alleged Trump and his allies conspired to overturn Georgia's 2020 election results. They used Georgia's RICO law, the same law used against organized crime and street gangs, to argue there was a criminal enterprise working to steal the election. They pointed to that phone call where Trump asked Raffensperger to find 11,780 votes. They pointed to the fake elector scheme. They pointed to efforts to access voting machine data illegally. They pointed to harassment of election workers like Ruby Freeman. 4 of the co-defendants actually pleaded guilty. Let me repeat that. 4 people in this case admitted guilt and took plea deals. Those plea deals are still binding, by the way. But the case ran into problems. Big problems. First, there was drama over Willis's romantic relationship with one of her prosecutors, Nathan Wade. Defense attorneys argued this created a conflict of interest. There were hearings. There was testimony. There was chaos. Eventually, an appeals court ruled Willis had to be removed from the case due to the appearance of impropriety. Then the case got handed to Peter Skandalakis, the executive director of the Prosecuting Attorneys Council of Georgia. He tried to find another prosecutor to take over. Nobody wanted it, so he took it himself. And just last week, on November 26, less than 2 weeks after taking over, Skandalakis asked the judge to dismiss the entire case. The judge agreed, case dismissed in its entirety. Now, why did Skandalakis drop the case? His reasoning is important. He said the alleged criminal conduct was conceived in Washington, D.C., not the state of Georgia. He argued the federal government was the appropriate venue, not a state court. He said pursuing the case would take another 5 to 10 years and wouldn't serve the citizens of Georgia. He wrote that there was no realistic prospect that a sitting president would be compelled to appear in Georgia to stand trial. Translation: we can't force a president to show up for a state trial. We don't have the resources to fight this battle for a decade, so why bother? But here's what's really wild. Skandalakis acknowledged the seriousness of the charges. He wrote that if proven, they would establish a conspiracy undertaken by multiple individuals to overturn the results of the November 2020 presidential election. He wrote that the strategy quickly shifted from a legitimate legal effort into a campaign that ultimately led to disruption of the joint session of Congress on January 6. He wasn't saying Trump was innocent. He wasn't saying the charges were false. He was saying, we can't do anything about it right now. And that right there is the whole story in a nutshell. The prosecutor who dismissed the case still acknowledged it was serious. He still acknowledged it could have proven a conspiracy. But practical reality won out over legal principle. So let's break this down into what it actually means, because there's a lot to unpack here. Point number 1, the evidence existed. The evidence was real, and it was extensive. This isn't disputed by anyone serious. Jack Smith documented over 250 witness interviews. He had text messages showing campaign officials calling the fake elector plan wild and creative. He had emails, he had call logs, he had the recording of Trump asking Georgia to find votes. He had testimony from Trump's own advisors saying they told him the fraud claims were false. He had evidence of Trump being told by Attorney General Barr that there was no widespread fraud. He had evidence of courts rejecting every single lawsuit claiming election fraud. More than 60 lawsuits, all rejected. Trump's own lawyers told him the theories were crazy. The report says Trump privately acknowledged that some of the claims from his attorney sounded crazy, but then he went out and repeated them publicly anyway. The evidence showed that when Trump was told he lost Arizona, he was told his campaign had no evidence of fraud. His response, keep pushing the lie. When he was told by the Michigan Senate Majority Leader that he lost because he underperformed with educated females, not because of fraud, Trump didn't want to hear it. When Georgia's Secretary of State refuted every fraud claim during that infamous phone call, Trump kept pushing anyway. He even threatened the Secretary of State, saying it was a criminal offense not to report what Trump falsely claimed was fraud. Smith believed he could prove Trump knowingly spread false election claims and conspired to obstruct the certification. Was Trump convicted? No, but the evidence was there. The prosecutors said so themselves in their final report. And here's something else people forget. 4 of Trump's co-defendants in Georgia actually pleaded guilty. They admitted wrongdoing. They accepted plea deals. Those admissions don't go away just because the main case got dismissed. Point number 2, the timing killed the cases. Look, there's no way around this. If these cases had gone to trial in 2023 or early 2024, we might be having a very different conversation right now. But Trump's legal team filed motion after motion. They challenged everything. They appealed every ruling. They argued about jurisdiction. They argued about immunity. They ran out the clock. His original trial in the federal election case was scheduled for March 2024. But by then, the case was stuck in appeals over immunity. And then the Supreme Court's immunity decision in July 2024 created even more delays. The case had to be restructured. New issues had to be litigated. Jack Smith had to file a superseding indictment that only included conduct that wasn't immunized. By the time the dust settled, Trump had won the election. And once you're president, the DOJ says you can't be prosecuted. End of story. Point number 3. The immunity ruling changed everything. This is the one people need to understand. Before the Supreme Court's decision, lower courts had ruled that Trump could be prosecuted. A district court said no immunity. An appeals court said no immunity. They ruled that former presidents don't get blanket immunity for crimes committed while in office. The appeals court wrote that for the purpose of this criminal case, former President Trump has become Citizen Trump with all of the defenses of any other criminal defendant. But the Supreme Court disagreed. In a 6-3 ruling, along ideological lines, they said presidents get absolute immunity for core constitutional duties and presumptive immunity for other official acts. Only unofficial acts can be prosecuted without immunity protections. Critics called it a license for presidential lawlessness. One legal scholar said it meant a president could openly commit official crimes with impunity. Supporters said it protects the executive branch from politically motivated prosecutions. Supporters said it protects the executive branch from politically motivated prosecutions. They said presidents need to make bold decisions without fear of being hauled into court later. Either way, it fundamentally changed what prosecutors could do in Trump's case. Some of the evidence they planned to use was now off limits. The case got weaker and more complicated. Point number 4. This creates a troubling precedent for the future. Here's what keeps legal experts up at night. If a president commits crimes while in office and then wins re-election, can they ever be held accountable? The federal charges have to wait until they leave office. But by then, statutes of limitations might expire. Evidence might disappear. Witnesses might forget things or pass away. State charges? We just saw what happened in Georgia. The prosecutor essentially said, we can't make a sitting president stand trial in state court. It would take 5 to 10 more years. So why continue? This creates a system where as long as you keep winning elections, you're essentially untouchable. You can run out the clock on accountability. Is that how it's supposed to work? Is that what the founders intended when they wrote the Constitution? I don't have the answer to that, but I do know it's the system we've got right now. And that should worry people on both sides of the aisle, because here's the thing. The next president who tests these limits might not be someone you agree with. The precedent applies to everyone. Point number 5, what happens next? Trump celebrated the Georgia dismissal on social media. He called it a witch hunt and said law and justice have prevailed. His attorney called it an end to lawfare and said the case should never have been brought. His supporters see this as total vindication. They say he was innocent all along, and the prosecutors were just playing politics. His critics see it as proof that the justice system failed. They point to the prosecutor's own words, saying the evidence was sufficient to convict. But here's the reality. These cases aren't fully resolved in the sense of proving innocence or guilt. They're just paused, stopped, put away. If Trump leaves office in 2029, could a future prosecutor revive these charges? Theoretically, maybe. But the practical challenges would be enormous. Witnesses would be harder to locate, memories would fade, evidence might be stale, public interest might have moved on to other things. And let's be honest, would any prosecutor want to spend years trying to build a case against a former president when half the country might see it as old news or political revenge? Probably not. So what's the takeaway here? The people who were ready to put Trump on trial are now quietly admitting the evidence was there. They believed they could convict, but the system wasn't designed to handle this situation. We had a president facing serious criminal charges. We had prosecutors who believed they could prove those charges beyond a reasonable doubt, but a combination of legal rulings, timing, and constitutional limitations meant no trial, no verdict, no final answer. Whether you think that's justice or injustice probably depends on how you feel about Trump. And that's the problem, isn't it? Justice shouldn't depend on whether you like the defendant. But whatever your politics, you should care about how this story ends. Because the precedents being set right now will affect every president who comes after. Democrat or Republican, liberal or conservative. The question isn't really about Trump anymore. The question is, can a president ever truly be held accountable for crimes committed in office? Right now, the answer seems to be probably not. At least not while they're still in power. And maybe not ever if they play their cards right. That should concern everyone. Because a system where the most powerful person is above the law isn't a democracy. It's something else. Make sure you hit that subscribe button because we're going to keep following this story. There's still more to unpack. The civil cases are still out there. The legal battles over immunity aren't finished. And the debate about presidential accountability is just getting started. This chapter is closed, but the book isn't finished. Not by a long shot. The civil cases are still out there. E. Jean Carroll won $83 million against Trump. That's still being appealed. The debate about presidential immunity is just beginning. Legal scholars are already writing about what this means for future presidents. And somewhere in a vault, Jack Smith's second report, the one about the classified documents, is waiting. We may never see it, or we might see it someday. Nobody knows. What we do know is this. The system was tested, and the system decided not to act. Maybe that's the right call. Maybe that's what the Constitution requires. Maybe sitting presidents really should be immune from prosecution. Or maybe, just maybe, we're watching something go very wrong. Something that future generations will look back on and say that's where it all started to fall apart. I don't have the answers. I just have the facts. And the facts are complicated. But one thing is certain. What happened here will have consequences. For years. For decades. Maybe longer. The precedent is set. The playbook is written. And the next person who wants to test the limits of presidential power, they're watching. They're taking notes. So yeah, this story matters. This story is one of the most important things we've covered on this channel, and I wanted you to understand all of it. Hit that subscribe button. Leave a comment telling me what you think. Do you think justice was served? Do you think the system failed? I want to hear from you. I'll see you in the next one.